Utah files a lawsuit challenging federal ownership of 18.5 million acres of land within its borders. Hello, I'm Richard Pyatt, and this is Legally Speaking. The lawsuit goes directly to the Supreme Court, where the state will argue the federal government's control of the land is unconstitutional. Attorney General Reyes said that Utah isn't allowed to watch over more than 2/3 of its own territory because it's controlled by people who don't live in Utah and who aren't accountable or responsive to citizens. It also isn't allowed to collect taxes on the land. This, of course, is a hot-button issue with conservationists, but an important one to state leaders who have been fighting this issue for decades. Utah's national parks and monuments are not part of this lawsuit, by the way. We have perspective on the lawsuit from Utah Solicitor General Stan Purser, who joins me now. Hello, Stan. Thank you for joining us.
Hey, Rich. Thanks for having me.
So why file this lawsuit, and why file it now?
Well, the lawsuit, from the state's perspective, goes to a very important constitutional issue. And that's whether the federal government is allowed to just possess or retain land that it hasn't appropriated for any enumerated purpose under the Constitution, and just to sit on that land over Utah's objection. And as you mentioned, the federal government's control of this land goes to some very important sovereign interests that the state has. We can't tax this land. We can't do infrastructure on the land. We can't improve roads on the land. We can't do eminent domain on the land. Just all the things that go along with Utah's sovereignty, we can't do on this land that's within Utah borders. And so it's a good question of why now. As you mentioned, that this has been an issue for decades. In part, the why now is answered. That's just when the lawsuit came together, but it's also now coming together against a backdrop of the BLM is issuing travel management plans that are closing off public roads, so our citizens can't access parts of this land anymore. They're passing new rules that may allow private entities to come in and lease the land for non-use, for conservation purposes, or just to keep people off. We're battling the federal government over thousands of what's called RS 2477 roads.
That's right.
So there's this backdrop of issues that Utah hasn't been able to make the progress we feel we need to just help our citizens have access to these public lands.
So if you go to the website that's available as a resource, standforourland.utah.gov, there's a map that comes up that shows all of the federal lands in Utah in red, and it also shows federal lands in the West and other states as well. It's a lot of federal land in the West that the BLM or other federal government, like the Forest Service has control of. So I imagine that other states are going to be keeping an eye on what we're doing and how ours progresses.
Yeah, we think so. As you mentioned that map, it is a particular problem in the East. The federal government controls roughly 69% of the land in Utah. In Nevada, it might be even more. And as that map shows, it's an issue throughout a lot of the western states.
So what's the legal grounds or the basis for this lawsuit?
Good question. So as we know, our federal government is one of limited powers. It's supposed to only exercise those powers that are listed or enumerated in the Constitution. And as the 10th Amendment says, if a power is not given to the United States, it's retained for the states or the people. And our position in this lawsuit is there's nothing in the Constitution that authorizes the federal government just to sit on unappropriated land that the government hasn't designated for any enumerated purpose, and just to sit on that land and not dispose of it over Utah's objection. The the Constitution does mention it does mention property in a few cases, but that's like in the enclave clause where the federal government can take control of lands that it purchases from states with the state permission, or in the property clause where it says, that Congress shall have power to dispose of land. And that's what this lawsuit is about, to have the Supreme Court declare the United States policy and practice of just retaining this land is unconstitutional and inconsistent with the federal Constitution, and to order the United States to abide by the Constitution. They need to start disposing of this land.
Okay. What's Utah asking for? What relief is the state seeking?
So, yeah, at this point, the sole focus of this lawsuit is to have the Supreme Court declare that the United States policy, which is in federal statute to retain these lands, that policy is unconstitutional, and then to order the United States to abide by the Constitution and start disposing of these unappropriated lands.
Okay, so we talked about this a little bit earlier, but we talk a little bit more about how much land we're talking about, just to provide perspective? What percentage of Utah are we talking about, and how does that compare? Can you give us some perspective about how much land we're actually talking about? Because I don't think people realize how vast Utah is.
Yeah,
down south especially.
In fact, I didn't realize it until I got involved in this lawsuit. The federal government overall controls about 69% of the land in Utah. Half of that is national parks, monuments, forests, military bases, tribal land. That's not involved in this lawsuit. We're not contesting those lands. But the rest of it, another 34% or 18.5 million acres, is this unappropriated land that the federal government hasn't designated for any purpose. And for comparison, it's roughly the size of West Virginia or South Carolina. Much bigger. You can name a number of small eastern states that could fit inside this territory.
It's a lot of land. You mentioned our national parks. How does this lawsuit affect our national parks, one of the crown jewels of the state?
Yeah, we are very proud of those national parks and appreciate all the benefits and the ability of people throughout the world to come see them and enjoy them. This lawsuit has no impact on those national parks.
Okay. Could you explain the Utah Enabling Act and explain how the lawsuit affects it? Does it basically undo the Utah Enabling Act? Kind of explain what it is first, and then how the lawsuit might affect it.
Yeah, that's a good question. So the Utah Enabling Act, before Utah became a state, the federal government, Congress, passed the Utah Enabling Act to allow Utah to begin the process of becoming a state. As part of that act, and as part of every other enabling act since Ohio became a state, there is language in there where Utah disclaims any right or title to the federal lands within the Utah territorial borders. But within that same act, it also contemplates that the federal government wasn't just going to sit on this land. The Enabling Act talks about the federal government disposing of these lands, and contemplates that Utah would get a percentage of the money of the disposal of those lands. So we think the Enabling Act is entirely consistent with Utah's lawsuit. It's that the government was never, the federal government was never intended or allowed or authorized to just retain huge swaths of Utah land and not do anything with it. There, as the property clause says, and as the Utah Enabling Act says, they need to dispose of it.
Mm-hmm. We need to do something with it. It sounds like a pretty important argument in this case, then, how that plays into it.
Yeah, it is very important. So sometimes critics of Utah's lawsuit or efforts here, I think, are misunderstanding our arguments. It's not that we're trying to take back land that was Utah's. We fully recognize that this was federal government land.
Mm-hmm.
We're just saying, federal government, you can't just sit on it for 130 years now.
Right.
You need to dispose of it.
Okay. So why file this lawsuit directly to the U.S. Supreme Court?
It's a good question. So both the U.S. Constitution and federal statute allow for some kinds of suits to be filed directly in the U.S. Supreme Court. And one class of suit that is allowed to do so is when the state, a state, is a party to the lawsuit, or the state is suing the federal government. And so we chose to, use those provisions to file directly in the U.S. Supreme Court for a couple of reasons. One, because this issue is so important and fully merits our Supreme Court's review and answer. And two, just the savings of time and effort. But because this lawsuit is a pure legal constitutional question, there's no facts that have to be developed in federal court with evidence or witnesses or affidavits. And the 10th Circuit, if we started in Utah Federal District Court, then went to the 10th Circuit, the 10th Circuit has already sort of opined on this issue, that it believes it's bound by some dubious precedent. So there's really no reason to go to the Federal District Court or to the 10th Circuit and then eventually to the U.S. Supreme Court. We believe this problem is so important, and as we talked about, involves so many other states and so directly impacts Utah's state sovereignty that it's fully worthy of going right to the U.S. Supreme Court.
Sounds like we're just cutting to the chase and going directly there. What's the process? Can the Supreme Court take a look at the lawsuit and then, like with an appeal, decide whether or not it's going to hear it or not, or does it have to hear it? What's the process there?
The Supreme Court views its original jurisdiction as discretionary. So it can decide, yes, we're going to keep this case or we're not going to. Part of our argument to the Supreme Court was, here are the reasons why this case merits your attention and that you should keep it and resolve it. So we filed on August 20th. The U.S. Supreme Court docketed it on August 23rd, and the federal government has 60 days to file their response. They may ask for an extension, and so that could be bumped out another 30 to 60 days. And then once the federal government responds, the case is then submitted to the court for them to decide whether they want to keep it or not. We'll be able to file a quick reply before the U.S. Supreme Court considers it. So we anticipate that the Supreme Court could make a decision later this fall or by the end of the year or maybe sometime in January.
Okay. So overall, it sounds like we're at least a year. I'm trying to get an idea of a timeline. Any idea how long all this is going to take?
Well, if the Supreme Court were to decide to keep it and they decided in late fall, December, or January, there would still be time for the court, if they wanted to order briefing and argument during their upcoming term. And traditionally, if they hear a case, argue a case during that term, they usually make a decision on it by the end of June. So potentially it could be decided, if the Supreme Court decides to keep the case, by the end of June 2025. Or the Supreme Court could have discretion to say, yeah, we'd like to hear this case, but we're going to hold it over and hear it in the October 2025 term. And so then it would be decided sometime then.
Well, it sounds like a pretty significant and major lawsuit with a lot of real important issues, and it's not surprising that it's going to take a little while to potentially hear all the arguments and cross all the T's and dot all the I's and whatnot. So, all right, sounds like a lot of work. Thank you for your work on it, and thank you for your time today here on Legally Speaking, Stan.
Thank you, Rich.
It's a pleasure to have you. And for our audience, thank you for joining us. We'll talk to you next time.